or third-degree felonies. If all of this was found true in these indictments, your punishment range is a second-degree felony. You're looking at no less than 2, no more than 20 years confinement in prison. Probation is not an option because you
after today, that offer will go up to 5 years. As you explained to her, you do have 2 pending third-degree felonies. You understand that, right?
You have to speak out so she
And then with that prior that you have on your record, you understand that you wouldn't be eligible for any kind of probation at a trial.
In each of these 2 cases. In summary, each of these cases similarly allege the third-degree felonies. It's going to be trial at another time, and that's weird. Okay, forget that. And here's you have to understand. Also, this alleges that you have been
Before this
convicted.
hearing even begins, you're about to witness a courtroom moment that takes a dramatic turn in a matter of seconds. At first glance, this looks like a routine plea hearing involving 2 felony charges for allegedly assaulting hospital personnel. But as the judge carefully explains the charges, the punishment range, and the consequences of a prior felony conviction, something completely unexpected happens that changes the direction of the entire case. The defendant is offered what many defense attorneys would consider a significant plea bargain. Just 2 years in prison for both cases, served at the same time. However, that offer comes with a strict deadline. Once today ends, the deal becomes much harsher. Throughout this hearing, you'll also hear the court discuss competency evaluations, sentencing enhancements, and why probation may not even be legally available because of a previous conviction. These legal details aren't just courtroom formalities. They completely reshape the risks facing the defendant. The biggest question is whether taking a guaranteed sentence is smarter than gambling on a trial where the potential punishment could increase dramatically. As you watch, pay close attention to every answer given in court because one unexpected response will leave everyone, including the judge, momentarily stunned. And by the end of this hearing, you'll understand just how quickly a defendant's future can change with only a few words spoken inside a courtroom.
And ma'am, your name, please.
Crystal Bass.
You're Crystal Bass. Okay, you've got 2 cases, Ms. Bass, in 25 CO 1809 and 1810. Assault on hospital personnel and hospital property. Each of these cases on or about, well, one wasn't alleging on or about November 8th, 2025, that event. And the other is on or about October 14th, 2025. And then the indictment, God bless you, goes on to allege that in 2019 you were convicted out of Hardin County District Court for attempted aggravated assault. So these 2 charges on assault on hospital personnel or third-degree felonies, if all of this was found true in these indictments, your punishment range is a second-degree felony. You're looking at no less than 2, no more than 20 years confinement in prison. Probation is not an option because you have, according to the indictment, been previously convicted of a felony, which eliminates any probation. Look at this. And she had earlier been evaluated by Dr. Ed Griffon for the issue of competency to stand trial. And Dr. Griffon, in a letter dated June 26th of this year, a week or so ago, deemed the defendant to be competent to stand trial. What are we doing?
Judge, I just wanted to go over her options with her. She has a current offer from Tommy Coleman, the new prosecutor in her case. That was only good for today. He's offering a plea for 2 years, running concurrently on each case. After today, that offer will go up to 5 years. As you explained to her, you do have 2 pending third-degree felonies. You understand that, right?
You have to speak out so she.
And then with that prior that you have on your record, you understand that you wouldn't be eligible for any kind of probation out of trial. Okay. And with that prior that you have on your record as well, that would also enhance you to a higher punishment range. So instead of your punishment range at trial being the 3rd-degree felony range of 2 to 10, it would enhance to 2 to 20. You understand that? You understand that you have a current offer on the table for 2 years TDC, and then you have 140 days credit.
This is one of the most important moments in any criminal case because the defendant appears to be accepting the plea agreement after the court and defense attorney carefully explain every consequence. Notice how the judge and counsel repeatedly verify that Crystal understands the charges, the sentencing range, the prior conviction, and the fact that probation is unavailable under the circumstances described. Courts do this to ensure that any guilty plea is entered knowingly, intelligently, and voluntarily. That protects both the defendant's constitutional rights and the integrity of the judicial process. At this point, everything seems to be moving toward a routine conclusion, but courtroom proceedings can change in an instant, and sometimes the most unexpected twist comes only after everyone believes the case has already been resolved. If you were in this situation, would you accept the guaranteed sentence or risk going to trial for a chance at complete acquittal despite facing a much greater
3 days
penalty?
credit.
Yes, ma'am.
Okay. And are you wanting to accept that offer, or do you want to set your face for trial?
I'll accept the offer.
Okay.
Is this a plea in each case?
Yes.
To run concurrently? Right. That's your understanding?
Is that what you want to do? You can set your case for trial.
Write it up.
I just need to make sure that you understand all of your options.
Write it up. That's good today.
Okay.
Thank you. All right. Thank you. We get to this here. 2 cases are now called. 25 CR 1809 1810. The state of Texas versus Crystal Bass. You are Crystal Bass, correct?
Yes.
And you are here with your attorney, Ms. Minaldi, and the state's attorney. Does the defendant waive formal readings of the indictments and arraignments? Can we proceed in summary?
Yes, Judge.
First of all, again, for the record, Dr. Edgar Pond analyzed the defendant for competency, and in a report dated June 26th of 2026, the court, Dr. Rapon deemed that his analysis showed the defendant to be competent to proceed to a resolution of her legal issues at this time, and that will be part of the record and sealed in each of these 2 cases. In summary, each of these cases similarly allege the 3rd-degree felonies of assault on hospital personnel in 25 CR 1809. The defendant is alleged to have caused bodily injury to a nurse employed at the Fannin Behavioral Facility. And in 25 CR 1810, the defendant is alleged to have caused bodily injury to a doctor employed at St. Elizabeth Hospital who was treating the defendant. In each of these cases, these are 3rd-degree felonies. The defendant has a prior conviction, but we are not moving on that, correct?
That's correct, Judge. Just proceeding from paragraph 1.
These are 3rd-degree felonies. In each case, the defendant faces, if convicted, a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here, ma'am?
Yes.
Agreements have been reached where you will be pleading guilty, sentenced to 2 years in prison in each of these cases to run concurrent. Yes, Judge. Is that your understanding of the plan?
No, I was wanting to, does that mean I get 2 years for each case?
That's right. That's what I just said.
Okay.
That's what we're going to do.
Is that about 4?
That's why I do this.
2.
Oh,
Yeah, that's why I do this. They run together
Okay.
at the same time.
Yes, sir.
Okay. People kind of get confused about that word. It's a big word and it's concurrently, but it means the same time. And consecutively means 2.
Yeah.
But these are 2 together.
Yeah.
That's your plan. If I follow this agreement in each case, you have no right of appeal of your cases. Do you understand?
Yes.
How do you plead in each of these cases? Guilty or not guilty?
Not guilty.
You've been pleaded not guilty. You're pleading not guilty or guilty?
Not guilty.
Oh, you're not guilty of these crimes?
No.
Oh, I thought this was a plea.
Judge, it was supposed to be. Plea.
Okay, we're going to trial.
You understand with the plea that you have to plead guilty freely and voluntarily.
I didn't do this.
Okay.
Are y'all kidding me?
No.
This is
Okay,
the
well,
moment
this-
that completely changes the trajectory of the hearing. After initially indicating she would accept the plea, the defendant tells the court she is not guilty. That single statement prevents the judge from accepting the plea because a guilty plea must be voluntary and consistent with the defendant's own admission in court. The judge immediately stops the process rather than forcing an agreement that no longer meets the legal requirements. The court then reminds the defendant of the very real consequences of rejecting today's offer, including the possibility of a much longer prison sentence if convicted after trial. It's a powerful example of how plea negotiations work in practice. Once an offer expires, prosecutors are often free to pursue harsher recommendations. Do you think this was a courageous decision to fight the charges, or a risky gamble considering everything the judge had just explained?
No.
Okay, well, this is set for trial. It's going to be trial at another time, and that's weird. Okay, forget that. And you have to understand also, this alleges that you have been convicted before and out of Hardin County for attempted aggravated assault in 2019. If you're found guilty in these cases, you will not be eligible for probation. Probation is not eligible. So you are looking at, if convicted, and you're not going to get probation because of this, if this is true, you are looking, because of the prior conviction, if convicted, you are looking at 20 years in prison, up to 20 years in prison on each case, which would run separately, 20 and 20. Okay, just so you know.
And you understand that today the offer was for 2 years, but after today, that's not offer.
Yeah.
So you want to reject the offer for 2 years?
Yes.
You're making that decision thoughtfully and upon discussions with your attorney.
Yes.
Okay, that's what you will get. Thank you. We'll set it for trial. What else?
Christopher Burkett, Judge.
This hearing serves as a reminder that criminal cases often hinge on decisions made in just a few moments. What began as a plea hearing with a negotiated 2-year concurrent sentence ultimately shifted toward a trial after the defendant rejected the agreement during the formal plea process. Throughout the hearing, the judge carefully explained the charges, the potential sentencing ranges, the impact of the prior conviction, and the legal consequences of proceeding to trial. Rather than accepting a plea that no longer reflected the defendant's position, the court moved the case forward for future proceedings, demonstrating the importance of ensuring that every plea is voluntary and legally valid. The ultimate outcome will now depend on what happens when the evidence is presented in court. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.